Thank you for inviting me here to speak on the subject of trademarks, copyrights, and designs. It's always a pleasure speaking to students because it kind of gives me a sense of pride to kind of introduce students to the law of intellectual property rights. Today, I have been given the task of speaking about trademarks, copyrights, and designs. The topic is wide and extensive. I will endeavor to compress everything into the 1 hour allotted to me. Good morning, everyone. Trademarks, copyrights, designs, patents are collectively called intellectual property rights. In its widest sense, a man's property is all that is his in law. In the legal sense, it is a bundle of rights flowing from ownership and possession. Property can be classified into the following categories: corporeal and incorporeal. Corporeal meaning tangible, something that can be touched or felt, like clothing, vehicle, business equipment, etc. And incorporeal or intangible assets or property, any property that cannot be seen or touched. Intellectual property is a property of that nature. Then there is another set of properties called movable or immovable property. Anything that can be moved is called movable property, and anything that cannot be moved is called immovable property, like land or benefits arising out of land, and things that are attached to the earth are called immovable property. Intellectual property is the property created by the intellect of human mind. Unlike other forms of property, intellectual property is a non-physical property which stems from or is identified as and whose value is based upon some idea. The idea is not something in abstract, but a physical, concrete, or tangible manifestation thereof, which forms the subject matter of the property concerned. Intellectual property rights are a bundle of rights given to persons over the creation of their mind, mental skill, and labor. Speaking generally, every man owns what he creates. That which he produces is his, and he has an exclusive right to use and benefit from it. The law, therefore, gives him a proprietary right in it, and unauthorized use of it by any other person is a violation of his ownership. In the realm of intellectual property, such rights exist in patents. The subject matter of a patent right is an invention or an improvement of an existing invention. Trademark, which is a manifestation or extension of one's goodwill and reputation. Copyright, right in literary, artistic, musical, dramatic, cinematographic work, etc. And design, rights in features of shape, configuration, pattern, or ornaments. I will be dealing with 2, 3, and 4 today. And I will try and quickly take you through or introduce you to the subject of trademarks, copyrights, and designs. Intellectual property rights reward creativity and human endeavor, which fuel the progress of humankind. They are a vital ingredient to inspiring innovations, promoting research and development, encouraging industrial growth and business environment, and markets by setting standards of quality and awareness thereof, financial gains to the owners and just cost to consumers, thereby contributing to the economic progress of the country itself. Some examples are the multi-billion-dollar film and recording and publishing industry, or the software industry, would not have existed without copyright protection. Likewise, the pharmaceutical industry would not have existed without a patent. And to instill confidence in the consumer, it is important to have trademark protections as well. It kind of tells the consumer that a particular product is of a particular quality and has a particular set of qualities, and assures the consumer of the quality standards of a product when he knows that a particular product comes from a Nestle company or a Coca-Cola company or a Nike or an Adidas company. Now, coming to the background or the origin of trademarks itself, the history of marks date back to the dawn of civilization. Very often I'm asked by students and even my colleagues and peers that is trademark or intellectual property rights laws new to India? The fact is no, it isn't. The concept of trademarks have existed for a long time. Now, for example, if you've seen this little diagram here, the sheep is marked with a numeral 53. Now, this is something that you see even today when you travel to the countryside. The livestock are sometimes marked. It is to identify the owner of the livestock. It is a kind of a mark or a trademark, or a mark, not a trademark really, but it is a kind of a mark to identify who the owner is. In the next stage, there were proprietary marks in the form of a name or a symbol affixed to goods. There have been archaeological findings of pottery with potter's marks to identify the maker of a particular vessel. Around the 10th century, a mark called merchant's mark appeared to prove ownership rights of goods. Now, the Trademarks Act by the Trademarks Act of 1999, which came into force on 15th September 2003. So if you ask me, before 2003, was there no act? Yes, there was an act. Before the 1999 Act came into force in 2003, the act was called the Trade and Merchandise Marks Act of 1958. And before that, there was a Trademarks Act of 1940. And before that, the Indian Merchandise Marks Act of 1889. Coming to the salient features of the Trademarks Act of 1999. Under the 1958 Act, a trademark could be registered only in relation to goods, not for services. When I say only in relation to goods, what does that mean? Now, the goods or services, all the goods or services are included into or segregated into 45 classes. So classes 1 to 34 are called goods, and 35 to 45 are classification for services. Like, for example, class 5 includes pharmaceutical products. Class 12 includes automobiles. Class 25 includes clothing items. Class 32 includes mineral water. Class 33 includes alcoholic beverages. Class 34, I think, includes tobacco and tobacco-related items. Likewise, The services are also segregated into 45 classes, from 35 to 45. Now, under the new Act, or the Trademarks Act of 99, which we call the new Act, a multi-class application system was introduced. Here, before this 99 Act, you could only file a single application for a single mark for a single class. But under the new provision, you can file one single application for one mark in multiple classes. So this application could be, for example, filed in classes 1, 3, 5, 7, 9, and 15. Then the definition of trademarks was expanded. Well-known marks have been accorded statutory recognition. Term of registration and renewal was increased to 10 years from 7 years. The scope of permitted use was enlarged, and provision was made for international registration of trademarks. Now, India acceded to the Madrid Protocol with effect from 8th July 2013. Therefore, an Indian business can use the protocol, the Madrid Protocol, to apply for registration in many countries, including USA, UK, or the European Union, and many other countries around the world. Likewise, a proprietor of a trademark sitting in, let's say, USA can use the Madrid Protocol to apply for registration of the trademark in India as well. Now, coming to the trademark registries, or registries per se, dealing with intellectual property rights in India. The trademarks offices are situated in 5 cities: Ahmedabad, Chennai, New Delhi, Calcutta, and Mumbai. However, the patent office is not there in Ahmedabad. It's only in Chennai, New Delhi, Calcutta, and Mumbai. And each is empowered on the basis of geographical region covered. There is only one common register. So despite the fact that there are 5 offices, the register of trademarks is only one. Now, before we start on registrability of trademarks, I just wanted to give you a sense of what is the worth of a trademark before we get to understand what a trademark is. Now, according to the Forbes annual list of world's most valuable brands for 2020, Apple was at US dollar 241.2 billion US dollars. Amazon was at 135.4 billion USD, and Coca-Cola at 64.4 billion USD. So just to give you a sense, while I was doing a matter for Nestle some years ago, I was told that its trademarks are actually worth more than the total value of all its physical properties all over the world put together. Now, what is a trademark? A trademark. Now, before we understand what a trademark is, it is important to understand what a mark is. A mark includes a device, band, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging, or combination of colors. Now, for a mark to become a trademark, it must have 2 other things. It should be capable of representation in a graphical form, and it should be capable of distinguishing the goods and services of one person from those of another. Now, the second part is very important. Capable of distinguishing the goods and services of one person from those of others. So, while like the moderator said, your questions have to wait till the end of the session. My questions can start anytime. Just to keep you guys awake and to ensure that this session goes well, I'm going to ask you a question. Can you identify the owner of this particular trademark here? Your comments can come in chat. This one, the one where I'm pointing to.
Yes, sir. Participant has answered. Many participant has written that it is ITC.
No, it isn't. It is Britannia.
Britannia also. Dr. Amit Patel also answered is Britannia. Britannia.
Yes. Now, there's a second one here. Can you tell me what is this one?
Yes, sir. Participant answered, it is Reliance.
Perfect. So, despite the fact that the word Reliance is not written there, one of you was able to kind of tell me that this particular trademark belongs to Reliance. So, moment you see this mark on a particular product, you will know that that product belongs to Reliance. That is what is meant by capable of distinguishing the goods and services of one person from those of another person. Now, just to take this forward a little bit more, can you tell me what this is? Which company does this belong to? When you see this bottle, what comes to mind?
Reply participant is Coca-Cola.
Perfect. So you looked at the shape of the bottle and you said that this is Coca-Cola. So if another person were to manufacture and sell a soda product in a bottle of this shape, you would assume that it comes from Coca-Cola. That is what is meant by distinguishing the goods and services of one person from those of others. Now, likewise, I am certain that you all know what this one is.
Sir, it is from Nike.
Perfect.
Many participants answered.
Right. Thank you. So now, just to give you examples of what a trademark is. Trademarks can be of various forms. It can be a word mark like Toyota. It can be a label mark like this one here, idea. It can be a monogram like this. Can anyone identify this monogram?
Yes, sir. Reply from the participant, it is Mercedes.
Perfect. In fact, yes, it is called the three-pointed star device of Mercedes-Benz. Now, just to give you an example of a case law that happened in India way back in 1984, there was a particular underwear company that started calling its undergarments dense, and they started reproducing this particular logo on it. The court took serious view of it and said that, look, while Mercedes-Benz does cars, you cannot use this particular three-pointed star device or the Benz logo, the word Benz, in relation to undergarments and undermine the well-known nature of the three-pointed star device. So that is the significance of a trademark. You look at it and you know that it belongs to a particular company. Likewise, the slogan, just do it. The moment you see the slogan, you know that it belongs to the Nike company. And there are trademarks like product or packaging designs. Now, coming to getting a little more deeper into trademarks to kind of understand what kind of marks can be registered. Now, what kind of marks can be registered? Or under Section 9 of the Trademarks Act, it says what marks cannot be registered. So a mark that is devoid of distinctive character. Now, this word devoid of distinctive character is very important. It is important because it is correlated with the definition of the trademark that I showed you 2 slides ahead. So it says devoid of distinctive character, that is to say, not capable of distinguishing the goods or services of one person from those of others. So therefore, if somebody were to use, let's say, Apple, the device of an apple to sell apples, is it devoid of distinctiveness? The answer is yes, it is devoid of distinctiveness. However, if another person is to use the device of an apple in relation to electronic goods, is it capable of distinguishing? Yes, it is. So, and then there are common shapes, like for example, the shape of a square or a circle or a rectangle. These are common shapes. These cannot acquire distinctiveness. It is devoid of distinctive character per se. Or alphabets, alphabet A per se. Can somebody monopolize alphabet A? If that is permitted, then all the alphabets will be monopolized within the next 30 seconds. Then what is prohibited? So just to clarify, what is prohibited is the marks that are not capable of distinguishing the goods and services of one person from those of others. The second set is marks that designate the kind, quality, quantity, intended purpose, values, or geographical origin of the goods concerned. So words like extra large, small, superb, best, fantastic, kilo, gram, numbers, these are to be avoided. And because these may not go through to registration. And then there are words which are common to the trade or likely to deceive or cause confusion. For example, somebody applies for registration of the mark Honey's Jammy in relation to, let's say, mixed fruit jam. And you see Honey's Jammy sitting on a supermarket shelf. So you pick up the product thinking it is honey, not because it is, because Honey's Jammy will be written on in bold and you think it is honey and you take it back home. When you open the packet is when you understand that it is a fruit jam or a mixed fruit jam. So that kind of a trademark which can cause confusion or deception to the public at large will not be granted registration. There are the other set of marks which cannot be granted registration are marks that hurt the religious susceptibilities. For example, Krishna for meat or meat preparation, or that comprises of scandalous or obscene matters, abusive words like bastard or FUQ, etc. Now we come to relative grounds of refusal of a trademark. So once you apply for a registration, these are the grounds that will be used to refuse your mark by the registrar. Or it can be refused in an opposition proceeding subsequent to its advertisement in the Trademarks Journal. So we will come to the process of procedure of registration a little later. Now, relative grounds of refusal. Mark shall not be registered if it is identical or similar to an earlier trademark in relation to identical or similar goods, and there exists a likelihood of confusion on the part of the public. So if you look at this one, it is BMW and BYD. Now, actually the marks if you look at the letters per se, it is BMD and BYD. They are not the same. But the idea that is supposed to be conveyed to the consumer at large is that of a BMW. Likewise, Aquafina and Aquamax for packaged drinking water. It cannot go through. They are confusingly similar, Aquamax, and look at the mountains and the overall color combination, and the way A is written. A is large in the mid at both the ends. So if you look at that, there is a certain amount of bad faith involved in this application for Aquamax. However, if this Aquamax were to be applied in relation to, let's say, water filters, the application will go through, because here then the goods are not similar. One is, it may be allied and cognate, that's a separate issue. There are case laws which say even for allied and cognate goods, the same or similar mark should not be registered. But yes, what I'm trying to tell you is there is a distinction here. So the important bit is in relation to identical or similar goods, and there exists a likelihood of confusion on the part of the public. Now, while selecting a trademark, one must be careful to avoid possible oppositions or on inherent distinctiveness, avoid possible opposition, avoid possible infringement action. Now, if there is an objection or an opposition or an infringement action, the cost of acquiring or obtaining a trademark goes up considerably. Now, if there is an objection or an opposition, of course, it benefits the lawyers always. It is the best for the lawyers if there is an opposition or an objection or a litigation. We make our money out of that. But from a client's perspective, it is always better to be very, very careful, do a search, see what are the marks that are available, do a good study, pay the lawyer a little money in the beginning itself, and ask him for his opinion on what kind of success their application will have before they apply for registration of a trademark or before they start using the mark. Now coming to, like I was explaining, a search should be conducted to ensure that cost of obtaining a registration is not too high. Now, when you are conducting a search, what are the things that you have to look for? Now, suppose your trademark was Nike, and you came across a mark called Ad Nike. Would this be a problem area? I would say you should look at it. You should report this to the client and see what they have to say. But suppose you came across something like Sriniketan. Would that be a problem? The answer would be no. Sriniketan is a word in its entirety, and it has no malafide intent when they are adopting Sriniketan. But as in relation to Ad Nike, there may be a bad faith involved, because this gentleman who is doing Ad Nike may be wanting to, kind of take benefit of both Adidas and Nike, and therefore Ad Nike. So therefore, you must look at the goods on which he is trying to apply the mark, whether it is for shoes, apparel, are the goods similar, and then report it to the client. Now, another one that one of those matters that I have dealt with personally is this one. The infringer had applied for the trademark or was using the trademark cricket, and my client's trademark was Kit Kat. Now, if you look at the way that is written, it is completely similar. an unwary consumer not having the benefit of side-by-side comparison is likely to get confused when you look at Kit Kat versus Cricket. Now, this was another interesting matter that we did. Now, if you know, Chanel is one of the leading perfume brands in the world. And there was another gentleman in India who was doing SHANELLE. And he was doing it for handkerchief perfumes. So when Chanel sued Chanel, this gentleman came and his defense was that they are pronounced differently. So when you are applying or searching for a trademark, you must look for marks which have phonetic equivalence. This is Chanel, and the other is also Chanel. And finally, you should also look at device marks. Device marks can be searched using the Vienna codification. Each device mark is represented in numerals, and once you have that particular correct numeral attached to a particular device, you can search for that device under the Vienna codification. Now, what are the trademarks that are not fit for registration? Track grip in relation to rubber tires for motor vehicles, because when you say track grip for rubber tires, it kind of says what is the intended purpose or quality of the product that is expected. Update for printed matter like newspapers. Update for newspapers, it lacks distinctiveness. Glass can in respect of glass beverage containers. Obviously, it is descriptive, though glass can as a one word is probably an invented word, which does not find a meaning in the dictionary itself. But when you look at it, you know it is glass can. There is no other way you can pronounce it. And therefore, in respect of glass beverage containers, it lacks distinctiveness. Profit maker in relation to financial and energy trading and risk management software. Again, lacks distinctiveness. And Surf Unlimited in respect of internet services, and Baby Dry in relation to diapers. Time to think again. Petitioner's mark was Ayur. The courts held that Ayu and Ayur are words belonging to public domain, and no one can appropriate it exclusively. Consequently, Ayur was removed from the Register of Trademarks. This was a case between Hindustan Lever and 3N Products Private Limited. Another interesting case to describe what is descriptive or distinctive is this. The applicant's trademark was Bliss, and it was in relation to condoms. The trademark registry held with respect to section 9. So when I say with respect to section 9, we are talking about lack of distinctive character. The mark Bliss does not suffer from any infirmity, as it has no direct reference to the goods, nor is it laudatory in nature. It is distinctive and for the purpose of registration. Again, another mark that came, which everybody knows about, is Postman. Postman in relation to edible oils. The other side came about and introduced edible oils under the trademark Super Postman. And the plea of the defendant was that the word postman is an ordinary English word, and the trademark will be generic and cannot be accepted. The court held that postman for edible oils is an arbitrary adoption, despite the fact that it is a dictionary word. It said it is an arbitrary adoption, and therefore the trademark for edible oils cannot be termed not an invented word, being an ordinary English word. Now, coming to the process of registration of a trademark. Once an application is filed, it is examined essentially on two grounds, like the two grounds that I explained before: absolute grounds of refusal and relative grounds of refusal. And these days, these examination happens within 21 days. Earlier, it used to take years before the Trademarks Office was able to examine an application. An examination report is issued. Once the examination report is issued and communicated to the trademark to the right holder, there are two possibilities. One, he has certain objections, or he has no objections and accepts the mark, in which case it proceeds further. If he has an objection or raises technical deficiencies, the applicant has to file a response. Once the applicant files the response, the Trademarks Office considers it and thinks that it is all right, and it goes to acceptance. If the Trademark Registry, considering the response filed by the applicant, is not satisfied, a hearing is appointed, and at the hearing, one has to present his case, and there are two possibilities again: that the hearing officer likes your arguments and is agreeable with the arguments that you've presented, and he accepts the case, or he rejects the application. If he rejects the application, there are two possibilities. You can file a review. Review always goes before the same hearing officer, or an appeal to the High Court. Earlier, there was, under this particular act, an Intellectual Property Appellate Board was created. But in sometime early this month, the Intellectual Property Board and some other tribunals were abolished by the government. So the Intellectual Property Appellate Board is one of the tribunals that got abolished by the act passed by the government in the monsoon session. Now, once the application is accepted, then it is advertised in the Trademarks Journal. Now, it remains advertised for a period of 4 months. And if there are no oppositions, the mark goes on to registration. Now, if there are oppositions, then you are required to file the counter statement. Then the parties will file evidence. Then arguments will be addressed by both parties. Hearing will happen, and thereafter, the registrar will decide whether your mark is capable of registration or not, or he refuses the mark based on the arguments presented by both parties. So if the mark is opposed, it is like filing a suit, and the procedure is the same. Both the parties file their pleadings and evidences are filed, then parties are heard and arguments are addressed, and the Trademarks Office passes an order. Again, there are two possibilities from a refusal order. Either you file a review, which again, like I mentioned earlier, goes before the same hearing officer, or you file an appeal to the respective High Court. Now, what are the benefits of registration? Benefits of registration are it confers exclusive rights upon the right holder. This is a right given by the statute itself. The registration is prima facie evidence of validity, and it gives the right holder the relief of infringement in appropriate courts in relation to similar or dissimilar goods. If you do not have a registration, you can still approach a court of law. But in that case, the case that is filed is for passing off. And when I say passing off, you have to establish, passing off is a common law right, and where your right must be established by documentary evidence. So if you have a registration, you can rely on the statutory right given by the registration. But if you don't have a registration, then you have to establish that right by putting documents on record to say that you have monopoly rights in a particular trademark. Jurisdiction of the court. All suits have to be filed before a district court. In certain states, High courts have original jurisdiction, and one can directly institute a suit in the High Court. So, traditionally, under the Code of Civil Procedure, a suit must be instituted where the defendant resides or carries on business, or where the cause of action wholly or in part arises. However, under the 1999 Act, and also as provided under the Copyright Act. So I will not be repeating this under the Copyright Act. That's why I'm mentioning it here. So under the Trademarks Act of 1999 and also under the Copyright Act of 1957, a suit for infringement can be instituted at the place where the plaintiff resides or carries on business. This is an exception to the general law provided under the Code of Civil Procedure. What are the reliefs available under civil action? You can ask the court for interim injunction. An Anton Pillar order can be obtained. An Anton Pillar order is an order where a right to search premises and seize evidence without the prior warning can be obtained. Direction to defendant to maintain accounts. Permanent injunction can be granted by court. Delivery up of goods can be granted. Damages or accounts of profits or costs, actual costs are rarely awarded. Now, that brings me to the end of my bit on trademarks. Now I'll start with copyrights. What is a copyright? A person's right to prevent others from copying works that he or she has written, authored, or otherwise created. Unlike other forms of IPR, copyright is a non-monopolistic right. It is a right against copying. So if you have sat in front of the Taj Mahal and another person sits in front of the Taj Mahal and draw the Taj Mahal, you are not copying from him or her. You are looking at the Taj Mahal and drawing. So it's a sketch that you make. So there is a possibility that two people may come and produce or make the same artwork, looking at the same thing, but it becomes an infringement only if one person copies from the other. It is intended to secure the labor, skill, knowledge, and capital of the author. Copyright subsists only in original work. It is, like I mentioned earlier, a negative right, the right to prevent others from misuse of original works. There is no copyright in ideas. Copyright subsists in the representation of an idea in a tangible form. Copyright subsists as soon as the work is created in some material form, immaterial, whether it is foolish or inaccurate. So what are the different kinds of copyright? Copyright can subsist in literary work, like books, tables, compilations, databases, including computer software. Dramatic work like recitations or choreographic work, entertainment in dumb shows, etc. Musical work, graphical notations of music, but does not include words sung, spoken, or performed. The words sung, spoken, or the words may form a part of the literary work. Artistic work includes paintings or sculpture or maps. Cinematographic work is your cinemas and sound recordings. So when an artist is singing a song, there are multiple copyrights available in that song. So the first right would be of the literary work. Second is of the performer. Third will be of the sound recording. Fourth will be of a musical work. The staff notation, in Hindi, what you call that, bol, and the tal. And so the musical work, the staff notation, is a separate copyrightable work. Registration of copyright is not mandatory to seek protection. However, it is advisable to register copyright in an important or extensively used work, since registration is considered prima facie evidence of ownership. It has a probative value. So this has been given to ensure that the author does not have to run around and acquiring a protection for his artistic work or a literary work. It is automatic. The moment the work is created, copyright subsists in it. What is the term of a copyright? The term of a copyright is lifetime of the author plus 60 years from the death of the author. So it is a long period. Now, now you look at enforcement. On the enforcement side, has got the Copyright Act has harsh criminal provisions, cognizable offenses. Arrest without warrant, minimum 6 months imprisonment, apart from exemplary damages for infringement of copyright. Jurisdiction, as I said, explained earlier, plaint can be filed in a civil suit where the plaintiff carries on business, and which is an exception to the Code of Civil Procedure. To conclude, all IP statutes, like all IP statutes, copyright protects innovation and creativity, thereby encouraging creation of more new works. It is kept informal so as to give automatic protection without going through the formal procedure for registration, so that artists are not dissuaded from the act of creation. In the words of Justice Chinnappa Reddy, an artistic, literary, or musical work is the brainchild of the author, the fruit of his labor and do, considered to be his property. So highly is it prized by all civilized nations that it is thought worthy of protection by national laws and international conventions. So this copyright law that gives protection to the author as soon as the work is created is not just special to India. It is by an international convention. So it is true for all countries who are party to that convention. Coming to the Designs Act. Designs and copyrights are somehow interlinked. The law of designs is covered by the Designs Act 2000 and the Design Rules 2001, which has been amended multiple times. The latest amendment was of 2021. Originally, they all came under the Patents and Designs Act 1911. What is a design? A design is a shape, configuration, pattern or ornament, or composition of lines or colors or combination thereof applied to an article, whether in 2D or 3D or both forms. So, for example, a jug of this shape has a design protection because it has a special shape and configuration or pattern to it. Likewise, a car has a design protection, or this, or the shape of the bulb itself. These are novel, new shapes which does not have anything to do with the functionality of the goods itself. Now, when does it become protectable under the Designs Act is when it is applied by an industrial process or means or by a combined process, which in the finished article appeal to and are judged solely by the eye. So, what is registrable as a design? Any design applied to an article which is new or original, that is, has not been disclosed to the public anywhere in the world, in any tangible form or by use or in any other way prior to the date of filing the application or the priority date. So if the design has been disclosed in any form, your design application cannot be filed, is significantly distinguishable from known designs or combination thereof, and does not comprise or contain scandalous or obscene matters. Now, even under the Designs Act, the goods are divided into multiple classes. Now, an international classification of industrial designs according to the Locarno agreement has been introduced in the Designs Rules 2001. The classification of goods is based upon the function of the goods. There are 32 classes and 219 subclasses. The same classification is followed all over the world. Example, Class 3 includes travel goods and personal belongings. Subclass 3.1 says trunks, suitcases, and briefcases. Subclass 3.3 says sunshades and walking sticks. And subclass 3.4 says fans. Now, coming to the flow chart for design application up to acceptance. Once you file the application is numbered and a date is given. Then the application is examined, communication of objections is made. If the applicant is able to remove the objection, it is re-examined and compliance of the objections happens in acceptance. It proceeds to acceptance, and from there it is notified in the official gazette, and the certificate is issued subsequently. However, from here, if upon communication of the examination, there is no non-compliance of the objection, it is abandoned. Or communication of the or examination happens and there is a hearing that is appointed, and the objections are waived or removed, and therefore either it goes to be accepted or rejected. Upon refusal, again, there is an appeal possible to the High Court. Term of protection. The term of a design registration is 10 years, and it can be extended by a period of 5 years alone. So it's a total of 15 years. Renewal fees must be paid before the expiry of the preceding term. Now, there is an interplay between the design and the Copyright Act. Section 15(2) of the Copyright Act says, no copyright if design is registered. So, if the design is registered, there is no copyright under the Copyright Act, which is available. However, if a registrable design, which can be registered under the Designs Act, is not registered under the Designs Act, it can be automatically protected under the Copyright Act. However, as soon as you make 50 reproductions of that design, copyright under the Copyright Act ceases to exist. So that brings me to the end of our session. And I think I have managed to cover all that I intended to cover within the allotted 1 hour. Now, if you have any questions, you can go ahead and ask them.
Thank you so much, sir. The session is now open for question and answers. If you have any questions, please write in the chat box.
Yes, sir. There is one question from the participant. The uniqueness of the trademark can be either inherent or acquired. One participant asked the question.
Yes. Uniqueness cannot be acquired. What distinctiveness can be acquired? Uniqueness can never be acquired. So under the Trademarks Act, there is a provision which is under Section 9. It says that a mark shall not be registered if it is if it lacks distinctive character. However, a descriptive mark can acquire distinctiveness by use. So if it is a descriptive word, it can be granted protection if it has acquired distinctiveness by way of use, is what is provided under the Trademarks Act. Now, is that clear?
Yes, sir. Sir, we have one more question. What is the difference between the service mark and trademark? Both
are trademarks. One is when I say service mark, it is used for services. That's all. Otherwise, both need to have the same qualities as is described, as I explained for trademarks. Consider both to be trademarks. One, when it's used for services, it's called a service mark. The other is commonly known as trademarks. But when you say trademarks, it includes a service mark as well.
Okay, sir. Thank you, sir.
Thank you so much, sir, for such an informative and interacting lecture.
Thank you. It was my pleasure.
Of the participants, but also he asked questions himself to the attendees, making the session more interesting for the participants. Sir detailed us with the trademark, copyright, and designs, starting from their background, their salient features, and the registration process in India. Sir also gave the examples of the live cases connected to the topics, and I think that was the best part of the session. Once again, thank you so much, sir.
Thank you.
As a token of our love and gratitude, I would request Dr. Kamal Kharecha, sir, to present e-certificate to to Mr. Philip Abraham, sir.
Good morning, sir.
Morning.
This particular course, you are requested kindly to accept on behalf of organizing committee, sir. Thank you, sir.
Thank you. Thank you.
Jay, yes, sir. This is your certificate, and thank you very much again, sir, for your fine presentation. Thank you, sir.
Thank you for inviting me. Thank you very much.
Have a good day.
Thank you, sir. Thank you so much.
Our next speaker for the topic Government Initiative to Promote IPR is Dr. Praful Bharadia sir. Dr. Praful Bharadia sir is currently working as a professor in Department of Pharmaceutics and Pharmaceutical Technology at LM College of Pharmacy, Ahmedabad. Sir has 30 years of work experience, which include 2 years of industrial, 5 years of research, and 23 years of teaching experience. Sir is an approved PhD guide, patents from which 2 are granted. Sir has published 5 books, 103 national and international publications, and has given around 35 presentations. Sir has been awarded the Indian Achiever Award for Education Excellence in 2010, presented at 26th Indian Achiever Summit on the Challenges of Economic Growth and Social Development. 22nd November 2010, Delhi, Rashtriya Gaurav Award in 2010 for Outstanding Contribution, Services and Achievements presented at Delhi, and Indira Gandhi Shiksha Shiromani Award in 2013 for Outstanding Achievements in the field of education presented at New Delhi. Sir is member of many reputed institutes like IPA, Ipr Ahmedabad, FICS, Ganpati University, Gujarat Technological University, to name a few. His current area of interest are modified excipients, CGMP implementations, parenterals, pharmaceutical process engineering. I shall request sir to begin his talk. Over to you, sir.
Thank you so much for your kind words of introduction. I hope I am audible to everybody.
Yes, sir, you are audible.
Okay, so very good morning to one and all. It is my pleasure to interact with all the participants of this 2-day program, which is organized jointly by Tolani College and LM College of Pharmacy, and which is sponsored by GUJCOST. Indeed, I have been looking through the lectures which have been conducted yesterday and today morning, and there's a lot of excitement. There's a lot of excitement which is generated because when we see the landscape of IPR, so many good things have been discussed. So my task of talking about the support or the government initiatives for generation of IPR or for IPR support is very difficult because most of the things have been already told by eminent speakers yesterday also, like say in the inaugural session by Shri Padmin Buch, he also had discussed so many things, support systems. Then we had a lot of good information which was provided by another session. So looking forward, let me try to discuss a few things which might be of interest to us, because as most of us would be from the academic institutions, let us have a look at what we can do and what support systems are available for us in academic institutions to our students and how to leverage these benefits. So I'll share a screen and we'll start the discussion. All right, I hope it's visible. Is it visible?
Yes, sir, it is visible.
Okay, fine, that's great. Right, so as we know, India has a wonderful, well-established legislative, administrative, and judicial framework to safeguard intellectual property rights which meets its international obligations while utilizing the flexibility provided in the international regime to address its developmental concerns. India has a trade-related aspects of intellectual property rights compliant, that strips compliant, robust, equitable, and dynamic IPR regime. The Indian IP system maintains a fine balance between private entities through its IPRs on one hand and the rights of the society as public on the other hand. This becomes very important because, as it has been said earlier also, that a country needs to safeguard the interests of its citizens. Therefore, any monopolistic system or a monopolistic regime which would generate out of an IP which is being filed would not be acceptable, because it would not be in line or in tune with the rights of the society. So that is where the involvement of the government would come in to take care. So we are interested in knowing that so many things are coming out when we have patents. We have seen about what is the benefit of patents and how they can be filed, what challenges are there, how litigations are taking place. So it is very interesting that first is, let us see how IPR is generated, which are the areas or the segments which contribute to the generation of IPR. So if we see the list of institutions, where we have academic institutions, colleges and universities, these are places where a lot of research is taking place, and this research may lead to the generation of IPR. Across India, we have so many universities, and these days a lot of focus is there on sponsored research also. So students, as they do their studies, they are also encouraged to take up some research work, and along with that, if some good output is obtained from that research, then an IPR is generated. The IPR generation is more from higher level research, like master's students, PhD scholars, slightly less from undergraduate students, but still there are so many initiatives now which are helping these academic institutions, colleges and universities in generation of IPR. The government has also understood the importance of building a grassroots level ecosystem for IPR, and therefore a lot of initiatives are being taken to push this across the country. As a result, we are seeing, because see, whenever we are looking at patents, from where would the patents come actually? We have to look at the sources of innovations, where innovation is taking place, and any innovation which will take place would lead to possibly a generation of IPR. Therefore, we look at primarily the academic institutions, colleges and universities as a major source of generation of IPR. Then next one is the industries. Industries, as they are doing manufacturing and they are involved in having a research and development centers in the industries, or they are developing new products, then they are also generating IPR. They may go for a patent, they may go for a design, they may go for a trademark. So that is much more related when the industries are working out with coming out of new products which are innovative. So then the industries are another source of generation of IPR. Then we have dedicated research centers which are functioning. These research centers are doing work on developing high-end research outputs, and these research centers would also be responsible for generation of a lot of IPRs. Then we have startups. Startups, as we all know, are very young and small entities which are based on innovative ideas. And these startups are being supported to a great extent by this government, and lot of initiatives are there in promoting startups in India. So the startups also, since they are based on innovative ideas, they also would be responsible for generation of either a trademark or a design or a patent, because they are working on innovative ideas. So startups are also another source where we can have a lot of IPR being generated. Then you have some ideas coming from the community, from even from rural areas. We may have certain innovative ideas coming in. So the community also may be a source of IPR, but to a lesser extent as compared to the other sources of IPR. Schools, if you go to see these days, uh, the amount of IPR coming out from Indian schools is pretty low, because that innovation concepts and an ecosystem does not prevail still in
Sorry for the interruption. We are having some network issues.
Fine. So, ત્યાંથી જ ગડબડ થઈ હતી. Sorry for the technical glitch. Hello, can we proceed?
Yes, sir.
Okay, thank you so much. We live with technical glitches and we learn from them. So going further, it is very interesting to note that a lot of focus is there on generation of IPR, because if you do not have sufficient intellectual property being developed, then the whole question of filing and all that does not come. We also understand that if India as a country has to progress, then we have developed a lot of expertise, a lot of intellectual property, and this has to come from our academic institutions by and large. So that whole ecosystem has to be in place where patents, trademarks, copyrights, all these are a talk of the institution, and students would be actively involved in all these activities, and they would be very comfortable and conversant with the regulations, procedures of going through all the IPR activity. Therefore, with that focus, even if you go to see the WIPO report on Global Innovation Index, India has been slowly progressing. In the yesterday's lecture, also we had a glimpse of the number of patents which are being filed by countries like US, China, and as compared to India. We also know that out of the patents which are filed in India, more than 50% patents are filed by other countries other than India. So Indian patent holders are pretty less in number. So looking at this scenario, the government has understood that unless we try to support these institutions, research centers, and industries also, that they are getting some funding or some other support which is required for the development of IPR, we may not be able to match up with the global requirements. Though we are a knowledge-based country and it has been accepted, we need to have a good support system, and therefore this has come up and it is being practiced since the last 5 years. We have seen a lot of development taking place. So going to the startup scenario, there is an extensive support system which has been created. We have business incubators. These incubators are supported by, say, Atal Innovation Mission like Niti Aayog. Niti Aayog has given these incubators across India, and they are sector specific. So depending on the area in which expertise is available in a particular university or an institution, it is provided with a business incubator. So like, say, for example, LM College of Pharmacy has an Atal Innovation Center, and that is for pharmaceuticals and healthcare. Similarly, other such incubation centers across the country have been established by the Atal Innovation Mission. So that is one support system where we are having a good ambience and facility which is being generated for startups, where they can come, they can grow their business, develop it into enterprise, and graduate out. Similarly, we have Department of Biotechnology, which has also set up incubators across the country. So that is also another source which is helping startups. We also have university-led incubators, where good universities have set up their own incubators and they are supporting startups. And all these business incubators, they have technical support for IPR. They have mentors on the mentor board who are supporting all the IPR related activities of these startups. Because these startups, since they are working on innovative projects, they always would like to protect the innovation with which they are coming out into the market with new products. So this is how various activities are carried out under the incubation center for supporting the IPR domain of these startups. I remember one nice example right now, that we all know these days that the mantra is Saraswati to Lakshmi, which means we regenerate knowledge, but the knowledge, if it is commercialized, it generates to monetary benefits. So we have a very nice example. I used to talk to one of the industries around over here. This industry is into oral fins. Say, for example, it's a one small domain which is known as oral dissolving fins. And this company has about 36 patents on film technology. This company has about 36 patents on film technology. And till date, they did not have their own manufacturing plant. Till date, they did not have their own manufacturing plant on this films in India. And they had worldwide patents on films. So I was just talking to them and I said, then what do you do? So they said that we have a team of 10 advocates or IP attorneys, and they keep on continuously scanning the world scenario. And anybody who comes out with a new product on a film, we sue that company because we have 36 patents on films and nobody can manufacture a film without our technology. So as it was discussed in the earlier session, it was very interesting. That is why I remembered this example. And so they have a litigation in court against that company anywhere in the world. And finally, because the technology is there, so they're holding the patents, they end up in maybe out of court. They may end up in out of court settlements or in court settlements where they may be provided royalty, or the company will have to stop marketing the product which has which has been prepared by them. So they said that we are generating about 24 crores worth of IP royalty only from these patents. They did not have their own manufacturing plant also till last year, but only through the patents on this film technology, they are earning about 24 crores per year. And now you can imagine that if in the laboratory you are doing some research and you are generating some good patents, you can imagine the amount of revenues which you can earn. That is why IPR becomes so important. And this company, so finally what happened was that the government also said that this is monopolizing the situation. So if you are not going to put up your own company, then we will do compulsory licensing of this product because it is needed by the community, and you have to commercialize or you have to put up your own factory also. So last year they have started their factory in India, in near Ahmedabad, and now they are also manufacturing these films. But point of interest is that the amount of revenue which they are generating just through patents of a particular technology. So when research is being done in academic institutions, in research centers, we can really, if it is done properly, we can understand the amount of revenues which can be generated through IPR. So this is how startups are also working, and we have support systems which are available. So we have a national intellectual property rights policy, that is NIPR, which is also there. And this is having a good objectives which have been laid down by the government of India. And it's a comprehensive national IPR policy, which is for stimulating innovation and creativity across all sectors. And it provides a clear vision regarding IPR issues. The policy document is available on the DIPP website, and you can go through it. Objectives which have been laid down in the NIPR policy is, first is, IPR awareness, building an ecosystem of IPR. That's what is basically required. So outreach and promotion are one of the aims to create public awareness about the economic, social, and cultural benefits among all sections of the society. Then for generation of IPRs, to stimulate the generation of IPRs, it gives support. Legal and legislative framework for the IPR background, and administration and management, that is to modernize and strengthen the service-oriented IPR administration, commercialization of IPRs. So to get value of IPRs through commercialization, enforcement and adjudication, to strengthen the enforcement and adjudicatory mechanisms for combating infringements. We have just seen how the infringements are taking place and how the cases are taken to the court and it is being resolved in the earlier lecture. Human capital development, to strengthen and expand the human resources, institutions and capacities for training, research and skill building in IPRs. IPR enforcement and toolkit for police. An advisory has been issued by the Ministry of Home Affairs to all the state police departments and academies to incorporate IPR in their training curriculum for both regular and in-service police officers. Technology innovation support centers are also proposed. Service level agreement has also been signed, and it has been set up. It is known as TISC. Sensitization programs for judiciary, the training of judges on the IP enforcement and adjudication. Why? Because whenever any litigation is going to be done, it's going to be done in a court of law, and therefore people in the judiciary also have to be trained on IP or IPR. So that is also in the National Innovation Policy. IPR in school syllabus. I was talking about how schools can contribute to generation of IPR. It is already there in the mandate, and in the content of IPR is being included in the NCERT curriculum of Commerce of Class 12. Also, it is there as an IPR, Innovation and Creative Works. That's also a chapter in one of the books. So in this way, slowly grassroots level percolation of IPR is being carried out so as to build the strong, robust ecosystem. Then we have IPR for startups and MSMEs. As I was talking about startups, but just not startups, even MSMEs are a big force in India because they are the backbone of the Indian industrial economy, and therefore giving them adequate support for protecting their technology which they have developed or their products which they have developed. The National Innovation Policy is also taking care of this. So under this scheme, the government bears the entire cost of a lawyer or agent who assists the startup filing of any number of patents, trademarks, and designs. So that's also in the mandate of the policy. So, and all the ministries under the government these days, they have been instructed to give maximum support to startups. So just taking one example over here, Ministry of Electronics and Information Technology, Government of India, it has a scheme to support IPR awareness for workshops, seminars in electronics and IT sector. So the criteria for final support is, say, for educational institutions, they are giving 2 lakhs. For industry bodies like MIT, all these NASCOM, FICCI, they're giving 3 lakhs. And then you have the societies, they're giving 5 lakhs. Similarly, they are giving support for market research reports, for list of patent facilitators, for list of trademark facilitators. There's a blog on startups. The National Innovation and Startup Policy is being discussed on that website. Funding guide is available for the startups. And there's a handholding support for awards also, because if good startups are coming up, then there's a startup awards also. So these are the resources which are available over there. Then there is another state level support system which is available, and that is known as Student Startup and Innovation Policy. Almost everybody over here might be aware of this policy because it is a state policy enforced by the government of Gujarat, one of the first in India. And therefore, a lot of enthusiasm was there when it was launched in 2017. Initially launched as a 5-year plan to see how it works, and then later on it may be extended. So the in case of Student Startup and Innovation Policy, proposals are invited by nodal institutions. Currently, there are 186 nodal centers in Gujarat state, which means each and every university, each and every good institution of repute will be having an SSRP center, a nodal center. These SSRP nodal centers are responsible for creating awareness of IPR, giving support, carrying out hackathons, boot camps, and training the students for innovative projects. So the proposals are invited by the nodal institution. There is a screening by an expert committee. After the screening is being done, funding up to 2 lakhs is given to innovative projects. Now this is this support is extended for developing proof of concept, where you have an idea and you want to try to escalate and to check that whether this is really working or not. So that's called proof of concept. So the funding up to 2 lakhs is primarily for developing proof of concept on any ideas which you may have. Then you want to build up a prototype. So the prototype can also be built from that support of 2 lakh rupees. If needed further, if the technical rigor of the project is high and further cost is required or the budget is high, then there is a support extended by the central SSIP of the state government. They can give you support up to 10 lakh rupees also. So the proposal has to be forwarded by the nodal center to the central SSIP that this project currently it has been sanctioned this much amount, and to take it further, it needs so much of extra funding. So there'll be again a state level committee which will look into the requirements and they'll take a call and they'll see whether the funding can be given to the SSIP team which is working on that project. So that is about innovative projects which are being funded under the SSIP support scheme. In SSIP, there is a patent assistance also. So up to rupees 25,000 are provided for patenting purposes. Recently, the policy has been revised before 3 months, and the patent filing budget has been extended up to 1 lakh. Now, this is very, very positive sign, because if a person wants to file a PCT, then he may not be able to do it in 25,000 rupees. And therefore, understanding this, and then there are other expenses which come up when the patent is published and it has to go for examination. We have to pay the examination fees, and then you have to maintain the patent also. But up to the examination fees and filing the responses, there may be cost incurred. Looking into all these costs, the SSIP has given a grant extension up to 1 lakh rupees. So this is a very, very welcome step which has been taken recently, and the students are taking benefit of that. So that is about the SSIP support which is available for generation of IPR, for filing of IPR, and for creating an innovation ecosystem. Looking at this policy of Gujarat state, other states have also tried to implement such policies now. So this is a document which is come out by the Education Department, Government of Gujarat, and that is known as Intellectual Property Guidelines for Academia in Gujarat. I hope most of you must have gone through this document. It's a very extensive document, and it is almost on the lines of the National Intellectual Property Guidelines. The state also has come out with its own intellectual property guidelines, and it discusses so many things. A few of them I will just go through right now because it is related to filing of IPR and the modalities consequences. So there it talks of two things. One is a university level and second is college level. So University Intellectual Property Facilities Center has to be set up in each university. That's what this policy says. And the goal would be primarily the universities, they'll have this for innovation and IPR related endeavors of students and research scholars and faculty members of the university. So that is promoted and that is suggested in the state level IPR policy. So the activities of this IPFC would be to facilitate end-to-end IP support and management solution to creators, and then it will be responsible for implementing the IP guidelines across all colleges which are under this university, build capacity among the stakeholders and maintain an efficient process to support the creators, and it will rank and prioritize patents for commercial viability and recommend and the approximate return on investment as an evaluation criteria to the funding agencies. Those are the activities which have to be carried out by the university level patent facilitation center. Then there is a college level IP cell, and the goal for this would be facilitating matters within a particular college which will implement the IP guidelines. And the activities over here would be facilitate end-to-end IP support and management to the creators approaching to the college IP cell. It will be responsible for implementing the IP guidelines across all departments involving students and alumni, and build capacity among all stakeholders and guide rightly. So at the college level also there is a Ipr Screening Committee. So whenever any research projects are being carried out or students are working on SSIP innovative projects, if some of the projects are found to be good, then they are first referred to an IP to a patent attorney, and it is checked whether it is patentable or not, novelty is there or not, commercial viability is there or not. And then if it is found to be good, it is put again to the IP Screening Committee. The IP Screening Committee will take a call and they will say, yes, out of these projects, this many can be taken further patenting, and then the patenting is carried out, support is given for patenting those ideas. So that is how the college level IP committee or the will be working. Then we have also the responsibility of faculty members, guides, and mentors. This becomes important because we have so many faculty members which may be attending over here. The state level IP IP policy, that's a state level IP policy which we are discussing. It also says about this, and this is what is important for us, that the faculty members, supervisors, guides should guide the students in IP filing applications if the students have done research work, innovative or new findings, which means that the mentors also should be taking an interest and they should take forward any new innovative work or research to patenting level. The faculty members should also keep record of the reasonable usage of institutional resources, if any. This is important. Reasonable use of institute resources. It has been specified in the policy what is reasonable use, extensive use. Because if the work has, because see, when the patent filing has to be done, whether the filing will be done, but it's a student who is working on an innovative project and there's some IP which can be filed. Whether the IP will be filed on the name of the student or whether the IP will be filed on the name of the college or institution or the university is generated from this, that the faculty members should keep record of use of reasonable use of resource, institute resources. Now this will determine whether the IP will be on whose name. So they shall guide and intimate the students if they're not aware on the research work and its potential. With the consent of IPFC, IP cell, they should ensure that the students are aware of the consequences if IP associated with a project is disclosed prematurely, which means confidentiality should be maintained for good projects and they should not be disclosed, otherwise it may be a problem when the IP is being filed. With the consent of the cell, they shall inform the students of the way in which the ownership is regulated and the rights and obligations are infringed. So this is also very nicely outlined in the policy. So I would request all the faculty members who are present over here and the research scholars to please go through these points of the state level IP policy. So managing of IP research, term papers and thesis, because most of the research scholars would be going through a research project and they will be submitting a thesis at the end of the research. So mainly you may have three types of IP which may be involved in this. There may be a technology revelation which might be protected by patent. The thesis might have a design protectable under design laws, or there might be a material or parts authored by students which might be protectable with the copyright laws. So these are three types of IP which may be involved during any research work being done by research scholars. So one has to be careful that we teach our students that these are valuable outputs which are coming out from the input of your 2 years or 1 year of research, and you should take advantage of this. So similarly, we have guidelines by MSME department, Government of India, and these guidelines are the implementation of the scheme for building awareness on intellectual property rights for micro, small and medium scale enterprises. Under this scheme, registered Indian MSMEs will be provided a one-time financial support limited up to rupees 25,000 for on grant or domestic patent and rupees 2 lakhs for a foreign patent. So this is also a good facility which is extended by the IP Facilitation Center of MSME. Funding is also given. There's a list of things which are available over here, where what type of activity and how much grant is available. This is for MSMEs. So there's a lot of focus on MSMEs because they are large in number and they have a good capacity of generating IPR. So the MSME department is also very strongly focusing on giving support for all these programs, where awareness and sensitization programs are there, pilot studies are there, interactive seminars and workshops are going to be conducted. Specialized trainings, if somebody wants to provide short term and long term, then you can have 45 lakhs you can get for a long term training program if any industrial based research center wants to conduct. Assistance for grant of patent and GI registration, again domestic, foreign and GI, it is given over here. Setting up of IP Facilitation Center for MSME, 65 lakhs is provided. Interaction with international agencies, domestic and international, again you have funding available. So this is the support which is extended by the MSME department, Government of India, and MSMEs can take advantage of it. Then eligibility is given over there, that who can take advantage of this funding, where you have MSME units, your organizations, your competent agencies, all these can take advantage. Like say, you go to MSME organizations, you can have industry associations, societies, cooperatives, firms, trust and other bodies, NGOs, research and technical and educational institutions, universities with a track record of assisting MSMEs. Recently, if you go to see this list, like the Attala Incubation Center of LM College of Pharmacy has also been identified as a center supported by MSME. So startups can go through the Attala Incubation Center of LMCP and they can get this facility. So with this, a lot of startups can go further and get support for their IPR based activities. So there's a robust support system which is being developed. So coming to NRDC, as we had a discussion on NRDC yesterday also. NRDC also helps in facilitating technology transfer since 1953. It's a very old organization which was an enterprise of the Department of Scientific and Industrial Research, and it has a work in the area of IP consultancy, technology transfer. It has a list of technologies which are being developed. Earlier, there was a coordination between DST and NRDC. DST, that's the Department of Science and Technology, used to carry out funding for various technologies across India. And all the technologies which were developed from DST funding, they were transferred through NRDC. So there was a tripartite agreement which used to take place, where three parties used to sign an MOU. One was the college, which was where the technology was being developed by a DST funded project. Second was DST, who was funding the project. And third one was NRDC, which was involved in the technology transfer of the project for a commercial use. In this way, a tripartite agreement was always there, and then the technology was transferred and it was commercialized. So that's been done since a long time, and those who are not aware of it, they can make advantage that this is the facilities which are being provided even by NRDC today. So technology assessment is also done. IPR Facilitation Center is also there. NRDC Innovation Facilitation Centers are also there. You can take advantage of this and go further for your IP. Going to the National Innovation and Startup Policy, NISP, the ministry has also come up with this policy. That's a National Innovation and Startup Policy, and this is being promoted through education institutions via AICTE. There's the All India Council for Technical Education, and NISP, ARIA, and IIC. IIC is the Institution Innovation Council, and This is responsible for again developing the ecosystem and creating awareness, designing programs for students in the institutions so that they are coming forward with innovation and innovative projects which can be later on funded by other agencies. So this NISP gives you a guide. It's a calendar of events which is given by, say, the IIC. That's to the IIC from MOC. And that is how the programs are implemented. Depending on the success of the programs which are being implemented by the IICs of each college, there is a ranking which is there, that is ARIA, and that ranking is on a state level and a national level, where the institutions are ranked according to the programs which have been carried out, according to the outreach which has been done, according to the patents which have been filed, and that is how the ranking is developed. So good performing institutions are able to get a higher ranking because they have a very robust system for supporting the students and a very good functional institution innovation concept. So these are various types of support systems which are available to the students, to the industries, to the startups in all. And this is what we can take advantage of and promote our IPR ideas. So I think this is the last slide. I'll close down over here. And if any questions are there, I'll be ready to take them. Thank you so much.
The session is open for question and answers. So if you have any questions, please write in the chat box.
Yes, sir. There are few questions. Can you explain procedure for patent application under SSIP scheme? What is the procedure for patent application under SSIP scheme?
If you want to apply for a patent under SSIP, we would look at two things. First is whether the proposal which you are having is really patentable or not. So there is a scrutiny which has to be done. So for that, we have patent attorneys on board also. So the SSIP center would have an IPR committee. In an IPR committee, there are members on board who are experts. There's an IP attorney also who is DIPP approved IP attorney who is on board. And the applications which are there, so you can apply to any SSIP nodal center with an abstract of your innovation. Then you may be called for a presentation. In a presentation, you may be giving details about the innovation which you have carried out or your new idea which you want to patent, whether it's a design or a copyright or a patent. And then since it is a new idea or an innovation, one thing which we should be careful about, that there's a non-agreement which is signed by all the members of the IPR committee also. So the risk of disclosure of that idea is not there, because that has to be very carefully taken care of by the SSIP committee also, that all the members of the to be worthy or patentable, they are taken up, they are listed in the minutes of meeting. A letter is issued to the person who is applying for the patent that yes, your proposal has been accepted, you can go for patenting. After that, the patenting can be carried out and the bills for patenting have to be submitted to the SSIP center, which will be reimbursed by the SSIP committee. This is how the process of filing a patent through SSIP can be carried out.
So one more question is that, is SSIP providing entire patent application fees for two different patents, like Indian patent system and PCT?
Yes, it is providing for both. Because even if you want to go for a PCT, first you'll have to file in India a provisional patent, and then you'll be able to file a PCT. So both of these are supported by, earlier PCT was not supported by SSIP because they said only 25,000 rupees, and that was not sufficient for filing a PCT. Now they have increased it up to 1 lakh rupees, and then they are also open that if required still further, you can come to us. We will see what is required. So both patents can be filed through SSIP. It happens sometimes. There's one very nice example where we had a discussion. I'll give you an example of that. That if a drug is repurposed, for another indication, then there are different views about patent filing. In India, it is not patentable. Whereas if you go to US, it is patentable. So there are certain differences which are there. So if you are working on repurposing a drug in India, you may not be granted a patent over here because it's not eligible. Whereas you can file the same patent in US. So if you want to go for a US patent, then you will have to first file a provisional patent over here. Then only you will be able to file a PCT, and therefore the process has to be done. But looking at these intricacies of what IP can be filed in which country, whether it's eligible or not, decisions can be taken wisely.
Okay, sir. Thank you, sir.
Yeah, thank you so much.
Thank you so much, sir, for such an informative session. Starting with the area for generation of IPR, sir also mentioned different policies like NIPR policy and student startup innovation policy. Sir also mentioned about the responsibility of faculty members, guides, and mentor in filing of patent for IP and how to manage IP research term papers and thesis. Sir also explained various granting schemes for MSMEs and the eligibility criteria for the same. Thank you so much, sir. As a token of our love and gratitude, I would like to request Dr. A.V. Bharati to present e-certificate to Dr. Praful Bharadia, sir.
Thank you, Dr.
Yeah,
Informative session, especially for academic fraternity, sir. We are obliged. Thank you, sir. As a matter of appreciation, please accept our certificate. We are obliged.
So
thank you.
Thank you so much. Any further details required or any support required on the SSIP front, I am available, and anybody can ask me at any point of time.
Sure, sir. Thank you.
Assist. Thank you so much.
Sure.
Thank you so much, sir. Now we will take a break from our webinar to have lunch. I request all the attendees to return by around 1:50 to 1:55 p.m. and rejoin the session using the same link. Thank you.
Thank you so much.
Thank you, sir.